Seated, everyone, and thanks everyone for being here. Is everybody ready to proceed?
Yes, they proceed now.
All right, then show the jury in. We agreed on 45 minutes. Anybody want any 2-minute warnings? Half and half, 2-minute warning. Okay, I'll give you that.
Can I get a 4-minute warning?
You got it. Good morning. You know, Memphis personally, y'all seem like really good people, but I hope today's the last time I tell y'all good morning. You know, yesterday, I trust no one had any problem with the court's instructions not to discuss the case, not allow anyone to discuss the case with you, not form or express an opinion, investigate the case in any matter. If you had any problem with determining in the trial of the case in that regard, speak now, forever hold your peace. I trust you have it. Yesterday, when we were breaking yesterday afternoon, I let you go early because I knew we had to get jury instructions together. I debated on whether just to keep y'all a while and see if we could get those done quickly and let y'all start the deliberations yesterday evening. But about 9:30 last night, when we were finally leaving the courthouse, I think I made the right decision to let y'all go home. But we have worked hard getting these together. We apologize for the delay to you, but as I said before, this is important. We want to get it right, and I appreciate y'all's patience with us. This morning, I am going to read you the jury instructions. You will then have closing arguments by the attorneys. Statements that bears the burden of proof will go first. The defense will then have its closing argument, and then the state will have its final close. I believe it's stated on the record, other than the objections previously stated yesterday when we were having our jury conferences, are there any objections to the instructions given? Any additional objections?
No.
All right. Here we go. Pay attention. I will say this. It's going to take a little while to read, bear with me, but you will also be given written copies of these jury instructions, but still pay attention. All right. Members of the jury, you have heard the testimony and received the evidence introduced in the course of this trial. The court will presently instruct you as to the rules of law which you will use and apply to the evidence in reaching your verdict. When you took your place in the jury boxes, you made an oath that you would follow and apply these rules of law to the evidence in reaching your verdict in this case. It is therefore your duty as jurors to follow the law which I shall now state to you. On the other hand, it is your exclusive province to determine the facts in this case and to consider and weigh the evidence for that purpose. The authority thus vested in you is not an arbitrary power, but must be exercised with sincere judgment, sound discretion, and in accordance with the rules of law stated to you by the court. Both the state of Mississippi and the defendant have a right to expect that you will conscientiously consider and weigh the evidence that apply the law of the case, and that you will reach a just verdict regardless of what consequences of such verdict may be. It is your duty to determine the facts and determine them from the evidence produced in open court. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. You are the sole judges of the facts in this case. Your exclusive province is to determine what weight and what credibility will be assigned to the testimony and supporting evidence of each witness. You are required and expected to use your good common sense and sound honest judgment in considering and weighing the testimony of each witness who has testified. Although you, as jurors, are the sole judges of facts, you are duty-bound to apply the law as stated in these instructions to the facts as you find them from the evidence before you. You are not to single out one instruction alone as stating the law, but you must consider these instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law, regardless of an opinion you may have as to what the law ought to be. It would be a violation of your sworn duty to base your verdict upon any other view of the law than that given. Arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but are not evidence. Any arguments, statements, and remark having no basis in the evidence should be disregarded by you. The evidence which you are to consider consists of the testimony of the witnesses and the exhibits offered and received. Production of this evidence, courts, is governed by rules of law. From time to time during the trial, it has been my duty as judge to rule on the admissibility of evidence. You must not concern yourself with the reasons for the court's rulings, since they are controlled and governed by rules of law. You should not infer from any rulings by the court on these motions or objections to the evidence that the court has any opinion on the merits favoring one side or another. You should not speculate as to possible answers and to questions which the court did not require to be answered. Further, you should not draw any inferences from the content of those questions. You would disregard all evidence that was excluded by the court from consideration in the course of the trial. You are not bound by any rules of parliamentary procedure in your organization or in your deliberation, but the court suggests that you choose a person to speak for you. You may vote on your individual belief either by show of hands, secret ballot, or any other method you choose. If in stating the law to you, I repeat any rule, direction, or idea, or if I state the same rule in a different way, no emphasis is intended, and you must not draw any inferences therefrom. The form of the verdict is suggested in another written instruction or instruction. Your verdict may be in one of the suggested forms, and it should be written in the handwriting or printing of one of the individual jurors on a separate sheet of paper furnished to you for that purpose. None of the individual jurors has to sign your verdict. The order in which these instructions are given to you and the manner in which the instructions and exhibits are numbered has absolutely no significance. You will have with you in the jury room all the papers and evidence applicable to this case. Although during the trial other papers, documents, exhibits, or charts may have been mentioned to you, once you have entered the jury room for deliberation, no other documents, papers, exhibits, or charts may be given to you. Transcripts of the trial testimonies or parts of the trial testimony are not available. When you enter the jury room for deliberation, the court suggests to you that you discuss the facts of the case and review these written instructions before you begin voting or attempting to decide the case. The burden of proving the defendant guilty of every material element of the crime with which the defendant is charged is upon the state of Mississippi. The law makes no distinction between direct and circumstantial evidence. It requires that before you return a verdict of guilty, the state of Mississippi must prove beyond a reasonable doubt that the defendant is guilty from all the evidence in the case. The law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state of Mississippi the burden of proving the defendant guilty beyond a reasonable doubt. The presumption of innocence attends the defendant throughout the trial and prevails at its close unless overcome by evidence which satisfies the jury of his guilt beyond a reasonable doubt. The defendant is not required to prove his innocence or to offer any evidence at all. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it will be necessary that each juror agree thereto. In other words, all 12 of you must agree on a verdict in this case. It is your duty as jurors to consult with one another and to deliberate in view of reaching an agreement, if you can do so without violence to your individual judgment. If each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your views and change your opinion if convinced that your previous opinion was erroneous. But do not surrender your honest convictions as to the weight of evidence or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of reaching a verdict. Upon retiring to the jury room, you will select one from among your number to act as a foreperson. The foreperson will preside over your deliberations and will be your spokesperson before the court. If it becomes necessary during your deliberations to communicate with the court, you may send a note by the bailiff. during deliberations, no member of the jury should ever attempt to communicate with the court by any means other than a writing, and the court will never communicate with any member of the jury on any subject touching the merits of the case, otherwise in writing or orally here in open court. Bear in mind also that you are never to reveal to any person, not even me, how the jury stands, numerically or otherwise, until you have reached a verdict, unless asked by me in open court. The defendant has a constitutional right not to testify on his own behalf in this case. You are not to make any conclusions or inferences of guilt about the defendant as a result of the defendant exercising his right not to testify on his own behalf. You will not consider in any way during your deliberations the defendant's decision not to testify. Each person testifying under oath is a witness. You have the duty to determine the believability of the witness. In performing this duty, you must consider each witness's intelligence, the witness's ability to observe and accurately remember, the witness's sincerity, and the witness's demeanor while testifying. You must consider also the extent to which the witness is either supported or contradicted by other evidence, the relationship the witness may have with either side, and how the witness might be affected by the verdict. You must consider any evidence of the witness character. You must consider any evidence of the witness's character for truthfulness. In weighing a discrepancy by a witness or between witnesses, you should consider whether it resulted from an innocent state or a deliberate falsehood, and whether it pertains to a matter of importance or an unimportant detail. You may reject or accept all or any part of a witness's testimony, and you may reject part and accept other parts of a witness's testimony. After making your own judgment, you will give the testimony of each witness the credibility, if any, as you may think it deserves. The weight of the evidence is not necessarily determined by the number of witnesses testifying as to the existence or non-existence of any fact. You may find that the testimony of a smaller number of witnesses as to any fact is more credible than the testimony of a larger number of witnesses to the contrary. Any fact in this case may be proved by either direct or circumstantial or evidence or both. Direct evidence is direct proof of a fact, such as testimony by a witness about what the witness personally saw, heard, or did. Direct evidence is a testimony of someone who claims to have actual knowledge of a fact. Direct evidence is simply evidence which, if you believe, it directly proves a fact. An example is a witness testified that he saw it raining outside and you believed him. That would be direct evidence that it is raining. Circumstantial evidence is proof of fact or facts from which you could conclude by your reason and common sense that another fact exists, even though it has not been proven directly. Circumstantial evidence is proof of one or more facts from which you could find another fact. Circumstantial evidence is simply a chain of circumstances that indirectly proves a fact. An example is if someone walked into the courtroom wearing a raincoat covered with drops of water and carrying a wet umbrella, that would be circumstantial evidence which you could conclude that it was raining. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. You as a jury should decide how much weight to give to any evidence. Deliberate design means an intent to kill without authority of law and not being legally justifiable or legally excusable. Deliberate always indicates full awareness of what one is doing and generally implies careful and unheard consideration of the consequences. Design means to calculate, plan, or contemplate. Deliberate design to kill a person may be formed very quickly and perhaps only moment before the act of killing the person. However, deliberate design cannot be formed at the very moment of the fatal act. The court instructs the jury that a killing occurring while engaged in the commission of a kidnapping includes the action of the defendant leading up to the kidnapping, the action of the kidnapping, and the aftermath of the kidnapping. The court instructs the jury that inveigle means to lure or entice through deceit or insincerity. Inveigling has no component of force, but only coaxing. Acting with a depraved heart is when a person acts in a highly dangerous way, which shows that the person does not care for the safety of human life. Even if someone does not intend to kill any particular person, he can still be guilty of murder if he acts with a depraved heart and a person is killed as a result. Culpable negligence is negligence of a degree so gross as to be tantamount to a wanton disregard of or utter indifference to the safety of human life. Negligence is doing something that a reasonable, careful person would not do under similar circumstances, or failing to do something that a reasonable, careful person would do under similar circumstances. Second-degree murder and culpable negligence manslaughter are distinguishable simply by the degree of mental state of culpability. In short, second-degree murder involves a higher risk of recklessness from which malice may be implied. The defendant, Sheldon Timothy Herrington Jr., is charged with the offense of capital murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did unlawfully and feloniously without authority of law and with or without any design to effect death, killed Jimmie Dale J. Lee III, a human being, while Sheldon Timothy Herrington Jr. was engaged in the commission of the crime of kidnapping by, with or without intent to secretly confine, inveigling Jimmie Dale J. Lee III with the intent to cause Jimmie Dale J. Lee III to be confined against his will, then you shall find that Sheldon Timothy Herrington Jr. guilty of capital murder. If you fail to find the defendant Sheldon Timothy Herrington Jr. guilty of capital murder, then you shall continue your deliberations to consider the crime of first-degree murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did willfully, unlawfully, and with deliberate design to effect the death of Jimmie Dale J. Lee III, killed Jimmie Dale J. Lee III, a human being, then you shall find Sheldon Timothy Herrington Jr. guilty of first-degree murder. If you fail to find the defendant Sheldon Timothy Herrington Jr. guilty of first-degree murder, then you shall continue your deliberation to consider the crime of second-degree murder. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, did willfully, unlawfully, and feloniously kill Jimmie Dale J. Lee III, a human being, without premeditated design to effect the death of Jimmie Dale J. Lee III, while engaged in the commission of an act eminently dangerous to others and evincing a depraved heart, regardless of human life, then you shall find Sheldon Timothy Herrington Jr. guilty of second-degree murder. If you fail to find the defendant Sheldon Timothy Herrington Jr. guilty of second-degree murder, then you shall continue your deliberations to consider the crime of manslaughter, culpable negligence. If you find from the evidence in this case beyond a reasonable doubt that Sheldon Timothy Herrington Jr., on or about July 8, 2022, in Lafayette County, Mississippi, unlawfully and feloniously killed Jimmie Dale J. Lee III, a human being, with culpable negligence by engaged in dangerous sexual activity with Jimmie Dale J. Lee III, then you shall find Sheldon Timothy Herrington guilty of manslaughter, culpable negligence. If the state has failed to prove any of the above listed elements beyond a reasonable doubt, then you shall find the defendant not guilty of capital murder, first-degree murder, second-degree murder, and manslaughter, culpable negligence. The court instructs you that all 12 of you must reach and agree upon a verdict. If the court instructs the jury that if all 12 of you reach and agree upon a verdict, you shall return the verdict to the court in one of the following forms. If you find Sheldon Timothy Herrington Jr. guilty of capital murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington guilty of capital murder. If you do not find the defendant guilty of capital murder, then you shall continue your deliberations, consider the lesser charge of first-degree murder. If you find Sheldon Timothy Herrington Jr. guilty of first-degree murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of first-degree murder. If you do not find Sheldon Timothy Herrington Jr. guilty of first-degree murder, then you shall continue in your deliberations and consider the lesser charge of second-degree murder. If you find Sheldon Timothy Herrington Jr. guilty of second-degree murder, the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of second-degree murder. If you do not find Sheldon Timothy Herrington Jr. guilty of second-degree murder, then you shall continue in your deliberations and consider the lesser charge of manslaughter culpable negligence. If you find Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence, the form of your verdict shall be. We, the jury, find the defendant Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence. If you do not find Sheldon Timothy Herrington Jr. guilty of manslaughter culpable negligence, then the form of your verdict shall be as follows. We, the jury, find the defendant Sheldon Timothy Herrington Jr. not guilty. Your verdict must be in one of the forms written above. You shall write your verdict on a separate sheet of paper. It does not need to be signed. Did the court read the instructions that were okay? Did the court read the correct jury instructions that have been decided by the parties?
Yes.
From the defense, did the court read the correct jury instructions?
Yes, Your Honor.
All right. As I said earlier, these jury instructions will be available to you when you begin your deliberations. At this time for the closing arguments in this case. When we start here, we're probably going to be probably an hour and 10 minutes for the first two rounds anyway. If you don't think you can stay that long, once we begin the closing arguments, I don't want anyone coming and going or moving around in the courtroom, okay? All right. Y'all got the door back there. Don't let anyone in once we start these closing arguments. I'll take a break after the defenses have to let anybody come and go that wish to, okay? All right, you may argue for the state, and here's your instructions if you want them, okay? Let me get my clock.
Ladies and gentlemen, good morning. We've been here a long time. Make no mistake about it. This case is about the death of Jimmie. Jimmie lived his truth. Jimmie, you heard all about it. But through the course of this trial, and I don't have very long, so I'm going to try to get to everything. But what the state has proven is that Tim Herrington lived a lie. He lived a lie to his family. He lied to Jay Lee to coax him over there, promised him to do something with him. That's what Jay Lee thought when he was going over there. If he'd have thought that he was going to be strangled to death, do you think he would have gone over? Ladies and gentlemen, that's embezzlement. That's coaxing. Not only did he lie to his family and his friends about his sexuality, being on the down low, they all thought he was into women. But we know that there was a secret that he was keeping in his life. He lied to them. He lied to his church, his family, his friends. He lied to Jay Lee to get him over that night because he had a problem that he had to fix. Then he lied to the police about everything. Deception, lies. He had to protect that lie. And what did he do to protect that lie? In order to protect that lie, he had to get rid of jail. And that's what he did. Now I want to go through and remind you about the proof. And before I do, you've heard four different, you've been instructed on four different crimes. Capital murder, first degree murder, second degree murder, and manslaughter. Manslaughter and second degree murder is negligence. The actions that were taken by Tim Herrington to protect his lives is not negligence. Those don't apply. Mr. Horan said that we were going to offer all those and throw it all against the wall and hope something sticks. That's how the proof is shown, and that's not what we've attempted to do. This is capital murder. That's committing murder in the commission of kidnapping. And I can tell you, in kidnapping and enablement, where it says, when you read about confining someone against their will, you heard another instruction that said that can be a bait and switch. Coaxing someone over is a deception, insincerity. That's what happened. That's what we proved. Now, earlier in the trial, when it first started, we put on a series of witnesses that told you about Jay Lee, about his life, about the truth he lived. When he was alive, he was on social media, he dressed fashionably, his life was vibrant. And how do we know that he is dead? Because the signs that his death left behind. You heard from Jennifer Buford. If you remember, she was the University of Mississippi advisor for his internship. He said that he had graduated. He graduated in social work, and that he was involved. That's the last thing to consolidate that degree was to complete that internship. And she told you that she had a lot of contact with him, and then it was stopped. She was like, "That's not normal." You heard from Jose Reyes. He described how that they were good friends, that they had the same interests, the Youngstown area, that he was living his truth, that he was unapologetically fashionable. He talked to you about that there were things that he loved. He loved his Pomeranian. I don't know if you recall, but he had a Christmas card that he had done with his Pomeranian where they both dressed up in pajamas. He had things that he loved. Interest. He was vibrant and happy. You heard Khalid Fears talk about his relationship. Just within the time they met at the park until July 8th when he heard from him that morning, he described him as vibrant and happy. That he, not having, didn't plan to go anywhere, and he was not depressed. He was not dealing with any psychological issues. And then you heard from Stephanie Lee. And if there's one thing that the state has proved beyond a reasonable doubt through Stephanie Lee is that she knew that her son was dead. Because on July the 8th, 2022, it was her birthday. And you heard about their relationship. They spoke multiple times a day, morning, her lunch break, and at night. And this was her birthday. She woke up at 7 o'clock that morning to a message that Jay Lee posted earlier in the morning and said, "It's your birthday." heard testimony from all these witnesses about things that he cared about. He cared about his car. It was a unique car. He loved it. Had, the Ford Fusion 2014 with the gold stripe on it. It was unique. You heard them testify that he couldn't have gone anywhere without any kind of financial means. Everything was there, the credit cards, the gift cards. You heard them all testify how he used social media every day. You heard Jose Reyes say, he was my little celebrity. People followed him on Facebook, Twitter, Instagram, Snapchat. And then after the morning of July the 8th, dead silence. You know from Jennifer Buford that he had the fundraiser project for his internship. He was still receiving packages of gifts for the children that were involved with CPS that were coming in after his disappearance. And you heard how much he loved that dog. And when that welfare check was conducted on his apartment at Campus Walk, the dog was there. But Jaylee's car was not. He loved that dog so much that he had a dog bone on the back of his car, a sticker that said, "I love my Pomeranian." And then we're going to get to what Miss Stephanie dealt with on her birthday. Not only her birthday, but now a day that she will forever, for the rest of her life, know is the day that her son was born. Talked about the welfare check on Jose Reyes. No activity of any kind on social media. You heard the condition of his apartment when UPD gained access to the apartment. There was nothing packed, no clothes missing, prized possessions still there. No indication of Jaylee leaving or planning to go there. And he had not had a history of ever doing that. Now then we get to the elements. so it continues on. You tried to do some questionable shit at me. That was too much. Have a good night, Tim. Tim still has a problem. Even Jay Lee thinks that, hey, you may just be trying to get me back over here so you can, beat my ass or something. Coaxing, luring, enticing. Where it says me, you tripping. I feel bad because we cool. So I ain't trying to end it like this. I'm trying to get them back. Jay Lee says, how we cool? Right under that, coaxing, luring, says, I'm saying you're a cool person. It's flattering Jay Lee. And right there, Jay Lee stops talking about the problem that they had earlier and starts talking about sex again, which is what they met for. They quit talking about the problems and they started talking about fun. And right here in the message, Jay Lee says, the only way I'm coming over is if you do something for me. It was conditional. And so what does Tim Herrington say? All right. More importantly is the timing of this. Because right after the conversation switches to the condition, you look at it, it's 5:45. And I do want to say where it says, why do you keep deleting that? I think when somebody's typing you a message and you see it, and then it deletes. Why do you keep deleting it? And Tim says, all right, so Jay Lee says, all right, I'll come back later tonight. Tim says, no, don't wait later. Come now. Jay Lee says, LOL. In response to luring, coaxing, insincerity, right there on the bottom right of the message, possibly later tonight, Tim Herrington, LOL. Trying to reduce the disagreement and make it friendly. Jay Lee responds with LOL. Then at 5:54 a.m., Jay Lee says, I'm coming over. I'm going to come over at 5:54. That's consistent with the campus walk video walks where we see Jay Lee leaving in the road with his key and his phone. Then, after 5:54, we know what Jay Lee's doing. What is Tim Herrington doing? Tim Herrington is searching. How long does it take to strangle someone? Right after this conversation. And then right after that, he talks about quick news for testosterone. This is the Google search. You can see the time, 5:57 a.m., July 2022. How long does it take to strangle someone? Then, 6:03 a.m., message from Jay Lee, Tim Herrington, says open. It's at the door. And that, ladies and gentlemen of the jury, is the last message Jay Lee ever sent. Why? Dead silence. Now, Tim had a problem. Jay Lee blocked him. Red Eye 24. Now, Tim Herrington's actions after Jay Lee sends that open message is proof of his crime. And you've heard, you've got the jury instruction on there about luring. You can take into consideration what in the commission of a crime means. A continuous crime from says, oh, he just came over to give me a gift. We cool. Everybody knows I'm leaving. You know, big man on campus. He was just coming to bring me a gift like everybody else. Maybe sat in his car for a little bit, and that was it. Lied to the police about the nature of the relationship. He also says in the interview that that when even in the second interview, he said, "Oh yeah, we just had a hookup, and he left. You know, everything was fine. It wasn't like he left mad or anything. But they said, did you go anywhere else?" And he said, "Yeah, we left at the same time, and I went to Walmart." Well, if you look at the Walmart video, you look at the Walmart receipt. He checked out at 6:49. What did he buy? He bought duct tape. You've also seen video surveillance of him looking at a big trash can, roll trash can. He has no need for it. Lafayette Police Department's got the dumpster. He says he's moving to Dallas in a few weeks. There's no need for that. Then he goes from Walmart in his Ford Escape, goes to the links and gets a box truck when he doesn't have a job to do. Tyson King said we didn't have a job to do. His witness, his best friend, Ken from Grenada, said if we had a job down there, he included it. There's no digital footprint, no messages of any job whatsoever in Grenada. He gets the box truck, comes back up. He's going back to that place. And then he stages the car. And if you remember, he told the police that he went for a run. That was the only place he went. He never said anything about going to Grenada. And investigators mapped out the back road run, 7.2 miles from 7. He was in Molly Bar Trails at 7:34, and he was driving by Coco's in the box truck almost 30 minutes early. There's no way to make that work. Lied to the police. Not only that, he's deceptive. He's trying to keep them away from looking at Jackson Road, which we've proven right here, that at 7:02, Jay Lee's vehicle goes by Rainbow Cleaners. And not only that, what's tracking with that car? Jay Lee's phone. And then it tracks all the way to Molly Bar Trails at 7:25. 7:26, Jay Lee's phone is silent. 7:26. Then we have 7:34. The video footage of Tim Herrington running out of Molly Bar Trail apartment. And we have that connected to the surveillance of him getting in Isaiah Carter's car, which he did. One of the most important things is on July 10th, UPD issues a press release that's out on social media. And if you look on the right side of that screen, Tim Herrington searches Molly Bar Apartments. In that press release, Molly Bar Apartments is not mentioned. Not only that, law enforcement is not even aware that Jay Lee's car is at Molly Bar Apartments. But Tim Herrington is. He's already searched. Then he searches the Alec Cosfield case. And then searches for Tony Freeze. We talked about it today.
You ready? You may. What now? All right, you'll take a minute. And if you take a minute, to set that computer up. If anybody needs to leave now, they can do so while they're or come in now. They can do so while they're shutting the computer up. But if you leave if the door's shut when you come back, you just out. Did you bring me some business, Sheriff? Have y'all got something out of Calhoun County today? I think y'all may have a plea out of chicken or something like that. It might be chicken. Ready, Kevin? All right. You said 4 minutes, didn't you? 4 minutes.
Just want to make sure we'll be able to look this up. Got it. Now, Chief,
You may.
ladies and gentlemen, like Mr. Creekmore said when we started this case, anticipating that the state would put on evidence and then try to convince you that these number of options that the state has proven, you would choose one of them. At the conclusion of his argument indicated the only evidence that you should consider, only verdicts that you should consider is capital murder. And I'm going to talk to you a little bit about the 4 options based on a lack of evidence. And that includes whether or not certain things that you felt like you should have heard, but you didn't. We're going to talk about those things right now. We're going to start, first of all, and I've got so many questions on this pad, and ripped off 2 or 3 pads. I'm not as computer savvy as Mr. Creekmore, but I'm going to talk to you a little bit about some of the things that we have problems with. Why in the world would an agency who spent $30,000 not on technology as far as computer stuff, all that's taken care of. Mr. Baker's training to do those things. They spent $30,000 and running, according to the chief, on collecting evidence from Timothy Herrington's apartment, Jaylee's car, and also from Tim Herrington's car. $30,000. Not only did they collect this evidence and did something they've never done before. Never done before. Sent it to a lab out in California for the sole purpose of making sure they can extract every possible bit of evidence from Timothy Herrington's apartment. Timothy Herrington's car, Jaylee's car, but obviously not, for whatever reason, Jaylee's car. And it's not that big a deal, Your Honor, ladies and gentlemen, that they didn't go to Jaylee's apartment initially. They needed to go over and get his toothbrush so they could compare his deal. But later on in the investigation, as the days traveled on, it seems to me that they would have gone over and said, hey, look, let's go in here and try to figure out whether or not somebody had been here after they interviewed all these people and said that Jaylee was having strangers and hookups coming into his apartment. Now look, folks, I'm not telling you they would have found anything over there. Not what I'm saying. What I'm saying is, on January the 21st, Timothy Herrington became a suspect. That stopped all the other investigations. On July the 10th, 2022, they should have treated Molly Bar Apartments like a crime scene. They didn't do that. No indication whatsoever moving forward to September the 5th, 2024, when they got this lab report, that they should have gone back to Molly Bar for the purpose of drawing DNA evidence. No, that's not what I said. What I said was that they should have reinvestigated their case after September the 5th, 2024, when this laboratory told them there's no evidence. Should have at least gone back to Molly Bar like they did when they went down to Grenada and went over to Lafayette Place. That's the whole purpose of that piece of examination. Now, ladies and gentlemen, I want to go down a few things real quickly before we move into some slides. You know, he indicated on his opening statement that my client was deceptive. Let's talk about deception in this case. Jose Reyes, he indicated, hey, look, I can't tell you anything about his personal life. Don't talk to Janelle. Again, what I'm trying to establish here, I want you to understand here, that during the course of this investigation, they should have broadened their scope a little bit more and say, let's look at these things going on in Jimmie Lee's life. Let's look at some of the other people outside of this direct circle. Let's look and see what's going on. What about Tylen Madness? You know, he's the individual that not only gave deceptive information, he's the individual they eliminated by virtue of the fact that his ping location was at his house. Said he was looking at porn. In testimony here, the phone that put the person there. Again, I told y'all, and I told Colin Mathis get the benefit and not Timothy Herrington get the benefit? Paying location, providing deceptive information. Why is the standard being applied differently to Timothy Herrington in that circumstance? Khalid Pierce had to show him an exhibit on the stand shown on the stand the conversation that he had with Mr. J. Lee about what? Choking conversation that they had between each other. That conversation pretty succinct, pretty detailed about what do you like, what you don't like. That happened in June, shortly before J. Lee had this encounter with my client. Khalid Fears was an associate, apparently, of J. Lee, and must have been pretty good friends because they were talking at 5:58 in the morning, 3 or 4 minutes. And if you remember, the conversation that we fought over in the courtroom, y'all heard us arguing about it, about what happened that particular morning, the conversation. Fears indicated from the stand that they had a conversation, and the gist of that conversation was what? Y'all remember? J. Lee told him he was going back over to a place that he had been before, hooked up before, and they were going to have some fun. Now, I'll tell you that what's important about that conversation is, if you look at it, and the conversation is on the screen pertaining to Mr. Fears, he testified that he remembered this conversation. Not only did he remember the conversation, he identified the conversation in the exhibit. This is exactly what he said. I like to go tap to tap. Fears. Okay, I'm not crazy. I feel like we are into BDSM. Lead during sex. I enjoy a little mutual aggression. Correct. Oh, you like to choke and be choked. Now, that's not Fears. That's J. Lee. What he testified from the stand, not only did he identify the message, he stated that he remembered that conversation specifically. Heavy on that. Do you have any kinks? I don't think so. I like to be aggressive and also put in my place. Now, ladies and gentlemen, I asked Brian Baker, Detective Baker, whether or not he had investigated or looked into the Snapchat history or the Instagram history of Mr. Lee and even my client to determine whether or not there was any similar type conversations between them in the history of Mr. Herrington and J. Lee consistent with this conversation. And I don't remember exactly what he said, but I think what he said, I didn't look. But wouldn't that be important to this investigation if they're going to claim that my client lured him over there for that to have occurred? But look back at the history. According to Mr. Herrington, they've known each other 2 or 3 months. Wouldn't you look at their history to see whether or not J. Lee, Timothy Herrington, had any type of conversation like that? Because the subpoena didn't go back that far, according to what we have in the cell record. All right. I want to talk to you a little about the first first conversation, the first time that night, Jay Lee and Timothy Herrington, there was any potential communication between the two. The first time was from not Timothy Herrington. It was from Jay Lee. It said, "You and Oxford," on the screen. "You and Oxford." That came from Jay Lee to Timothy Herrington. The conclusion of that text, that snap, what happened then? Timothy Herrington didn't respond to that message. Jay Lee is the individual at the time of that text. It says at 2:24:44, Timothy Herrington did not respond. Now I'm going to tell you, ladies and gentlemen, first thing I'm going to say straight up front. We introduced the lock audit report, and the state was slamming and going crazy about it. That's not reliable. Well, this is what they gathered in their investigation. And I thought it was quite odd every time that there's a piece of evidence that supported the defendant. It's not reliable. The lock audit, the burglary report, y'all had both of those reports. You remember what Detective Baker said about the burglary? I'm going to skip to the burglary real quick. I mean the lock audit. Go back to the lock audit, then I go to the burglary. You remember what he said on the stand when he identified the document? We got an email telling us that lockout report wasn't reliable. Ladies and gentlemen, I'm going to let you decide. This ain't evidence. I'm going to let you decide if it's reliable or you can consider it. But this is what we understand happened through the lockout. And it appears to be, according to the evidence that they got on the search warrant, they got a search warrant on July the 22nd, the same day they went in Mr. Harrington's apartment. They got it for the lock audit for the resident key of his apartment. Search warrant returned for Timothy Harrington's lock audit. The door opens July the 8th, 2022, 6:41. Door opens July 8th, 2022, July 8th, 6:45. Ladies and gentlemen, y'all take that lock audit, you put whatever weight and credibility that you want. But they didn't spend $30,000 or $3 trying to determine whether or not that was accurate. He just said it was unreliable. We said from the stand, he said he had an email from somebody that said it wasn't reliable. It was never introduced in the evidence, folks. Never was. Now, getting back to conversations that morning, I asked the chief what conversations were in there that showed that the whole theme of this case had been proven that my client was getting out. Now here's two guys, young guys, talking to each other. Nobody's looking into their world at all. You would think that you would have all kind of conversations where 3 days ago or the last time they hooked up, there would have been some beginning of some problems with their relationship. So you go to the next message, the Instagram message, where Jay Lee, this word "say," according to the chief, one word in the Instagram message, number 4. I just wanted to be able to say, I had you, did. Now, Detective Baker, as you recall, when I specifically asked him, I said, Detective Baker, you can't tell us what the context of these conversations are. And I made reference to the conversation conversation in the bottom of the Snapchat pertaining to something about like to try to hurt me or something like that. He said, we have no idea what their prior conversation was about. That's exactly the point, ladies and gentlemen. We have no idea what these two young men talked about when they had a 14-second Snapchat conversation before we came over. We don't have any idea. But right here, Chief of Police, Oxford, Mississippi, when asked, what information do you have that supports the idea that he was about to out him? I just wanted to be able to say, I had you BDL. Again, Fund had been the first guy experiment over. What does that tell you? What it tells me, and the reasonable interpretation is that Jay Lee's making a comment to Timothy Herrington, hey, you had an experiment over. I don't know exactly what they're talking about, but it didn't sound to me like Jay Lee is making any type of threat to Timothy Herrington that he's going to out him. That's what the state wants you to believe. But this man killed Jay Lee over this one word. He said, say. That's what he testified to under oath. You go down to the remainder of it. He said, also, I nutted on your floor, so you should get that up, by the way. Oh, and the nude was fake too. Back to block now. He's blocking Mr. Herrington, according to this, again. Put anything in evidence that he had even blocked him that particular night. He said, back to block. Hang up on him. Our conversation is over. Now we go to the next Snapchat, and I'm going through these because I think it's very important. I've talked about the 14-second call. But I go down to the next one where the Snapchat red eye. Who the TF is this? Now think about that red eye account. Ryan Baker admitted that he had testified under oath previously that my client created that account for this transaction. We testified to, I showed it to him, his prior testimony, and he admitted, created that. I testified to that. Fundamentally false. I don't know if he had bad information or he misread it. I don't know. But that's the critical part of their case, whether or not this young man created this account for the sole purpose of luring him over. I'm not saying he didn't reopen it. That's not the point. They admitted on the stand. They do that all the time. Who the TF is, that's a response from Jay Lee to an invite from Timothy Herrington. He's accepting that, is what he's doing. The next Snapchat involves basically, he says, what did you delete? These are conversations, if you read them in context, what you can understand is Jay Lee is the one controlling this conversation. It's clear from that Jay Lee is controlling the conversation the entire time through this Snapchat history. He says, what did you just delete? You made it like this. And when you get over here, you wouldn't even eat my ass 1 hour ago after I cleaned and everything. Then you proceed to nut in my mouth. Think about that. I hate to talk about this stuff, but this is what the facts are. Think about what happened later on in the fears statement when he says that he's going over there to do something we've never done before. It can't be that Mr. Herrington is going to give him more sex. It can't be. This conversation right here contradicts that. Then he goes into all this information about effing nobody raw. Then he says, I'm going to stop harassing you now, and that you want to stop blinking. You know how much of an asshole move that is. What he's saying is apparently he's upset because Mr. Herrington is telling him, maybe we're not going to look up anymore. Right. Now, the Snapchat conversation next is the 14-second call that we talked about a few minutes ago. 14 seconds. They had a phone call and asked Mr. Baker about it. Nobody knows what that conversation was about. Nobody has any idea whether that conversation referenced any prior conversation or something they talked about when they got together earlier that night. Who knows? And I talked to y'all when I did open statements, talked about speculation and wonderment, drawing conclusions, making the quantum leaps. That's what the state wants you to do. That all this conversation, they want to connect the dots with speculation, no facts to support, because we just don't know what they were talking about. Now, if you look at the next Snapchat we're going to talk about, it's number 8 in my list, questionable stuff before. Try not to say cussing in here. Like you done did some questionable SHIT before. But that was too much. Do we have any idea what they're talking about? Absolutely not. There's nothing else in that in the text string tells you whether or not they were talking about our sexual activity, doing anything moving forward, or anything that they'd done 3 months ago. It's not in there. We don't know. Remember Ryan Baker's testimony. We have no idea what they're talking about. And here we go. I'll come if I get head in front of him. Jay Lee is controlling the entire conversation between these two individuals. It's obvious and apparent from this conversation. You move on down to the conversation that they continue to have that night. All this is in evidence. You'll be able to look at it. But if you move on down and you look at some of the conversations that they had, it continues the same way. Have a good night, Tim. Only way I'm going to see you if I get head up front. And you keep going down, and Tim says, okay, why do you keep deleting? And that's just okay. Timmy says, I'm sorry, I misspelled something, and okay, I'll do it. That's Jay Lee telling Timmy, what are you deleting? He's the one that's being the dominant actor in this particular conversation, not my client. You know, if you try something fast, it won't end up good for you tonight. Where in that conversation that they just had warranted some kind of comment like that from Jay Lee? Does that mean he's scared? No, he's the one saying, I may or may not come over there. If you look at the remaining of the text, he's the one that makes his comment. What prior to that warranted that? My client says, what do you mean something fast? Like hurt me or some shit. Where's the threat there from Mr. Herrington? Where is the alluring aspect of this conversation? Timmy says, I know. And Jay Lee says, possibly tonight. But then he goes on to say, puts conditions on it. He continues to say, basically, I'll come later on tonight. And Timmy says, I told you I'm leaving later today. And we know that's true. Because if you go back to the prior text message about the screws, we do know that Mr. Herrington, all this is in evidence, talk about trucking company. He's talking to Tyson. He's talking to Mr. Love, Darius Love. He says on here, says to Tyson, I'm going to need those screws tomorrow. They go through this. I left them at Love's house. You're going to have to go get them. I'm in Hattiesburg. Then they talk about the tool bag. I'm going to leave around 9:30. He's telling Mr. Lee, you coming up? I got to go somewhere tomorrow. If you come, I'm letting you know. When Mr. Lee says, I'm probably coming, I am not going to be here throughout the day. If you come on. Now, I kind of skated over this, but y'all remember that Mr. Lee, the first time, 4 o'clock, goes to Mr. Herrington's apartment completely unannounced. Ron Baker admitted to that. Completely unannounced. Second time he comes over, after 14-second phone, that 14-second conversation, the last thing that happens at 6:03 is the Snapchat of open. No doubt about it. That does not mean that's when Jay Lee went in the apartment. It says open. At 5:54, he says, I'm coming. And he says, what's that mean? Apparently, ladies and gentlemen, Mr. Lee consensually went over to, obviously consensually went over to Mr. Herrington's apartment. And we're going to talk just a little bit about how long does it take to strangle. Nobody ever testified that the context of that search was how long does it take to strangle someone. Now, if you recall, again, Mr. Baker, Detective Baker, testified August the 9th, 2022, that was the search. And he admitted when he testified to that, that was not factual. The text was, the search was, how long does it take to strangle? Do we know what context that was? Absolutely not. Do we know whether or not that was based on something that Mr. Lee had said to Mr. Herrington, consistent with the conversation that he had with Mr. Fears about what he'd like to do? Absolutely not. But there's a possibility there, ladies and gentlemen, and more likely, probability. Because how do we know that Mr. Herrington wasn't taking that very seriously? Because 7 seconds later, point in time, that got to type it in for Detective Baker. He was looking at something else. He was on Instagram. He was no more paying attention to that man in the moon. Agreeable with Detective Baker? Ladies and gentlemen, I'm going to go through some of the questions that we have about this case. Why in the world would these exhibits we talked about not sent to the lab? Why wasn't George Shiro here? You're not going to hear, you didn't hear from Mr. Shiro, but you heard from some of the stuff in his report. Why would Mr. Shiro, Mr. Shiro's report said they did not request fingerprints. Request condoms, didn't request keys, latex gloves be tested. None of those things were tested. Y'all heard that. I want to go through some more of the things that we have some concerns about. Think about this right here, folks. After the lab report came in, and they got it, and no doubt they at least had a preliminary report before, they go down to Grenada and start searching 2 locations. Lincoln Road, where they've been before, and they go down south of the Herrington home. We don't have any idea if they took drones down there, people down there, what they took Ladies and gentlemen, answer this question right here, if you can. Why in the world David Mr. Porter would not provide a report on something they did 4 weeks ago? Why would they do that? Why would they not provide that report? The Burley report is in evidence. I want to talk a little bit about that. The Burley report provided Mr. Lee's car, the door open and closed, another fight in this courtroom about that particular item. The search warrant returned for the Ford Fusion Burley report. At 7:34 a.m., driver door open, closed. 7:34:48 p.m., the passenger door open. That's the Burley report that was introduced into evidence. You will have it. I encourage you to look at that page in that Burley report. 7:34 is what time, ladies and gentlemen? That's the time they claim Mr. Lee car 7:25 went in 7:34. My client, close proximity at that time, sitting on camera, running away. 9 minutes from the time the car went in, the time that my client, it can't be both, ladies and gentlemen. It can't be both. He can't be running away, and also he can't be opening and closing that door. Can't be. Now the Burley report, again, testimony from an officer that said, hey, look, you can't depend on that report. It's unreliable. Now, he didn't tell us why it was unreliable, how it was unreliable, or what mechanism they proved that it was unreliable. All they said, it was unreliable. I want to talk to you a little bit about what happened in Timothy Herrington's car and the times and things that they claim happened in the car. 6:03. They claim Mr. Lee at least said open the door, and later, maybe a minute later, maybe 3 minutes later, showed up Mr. Herrington's car, went inside. Something happened. Think about the fact that he's in Walmart at 6:41. He's in Walmart. Checks out 6:49. If they'd gone in there and talked to the attendant to say, you know, he was looking at this garbage can, what he would say to you? They didn't do that. And why would Mr. Herrington be getting a garbage can in his car? Why would he be doing that? And think about this. Question that I've had ever since we started this case, and they give me the discovery in this case, it's like I was before. How is it that Mr. Lee is at Mr. Harrington's apartment at a time when the lockout report says activities going on at that location? Ladies and gentlemen, I want you to look at that. I've got 2 questions that I want you to consider here. Maybe the biggest 2 questions in this case. The first one is, how does the state establish beyond a reasonable doubt that Jay Lee was not alive with Timothy Herrington when the car arrived at Molly Bar Church? No one's testified that the identified identified Mr. Herrington driving the car or Mr. Lee? Think about the fact that fingerprints that were found in his car were Jay Lee's fingerprints. Think about the fact that Mr. Herrington's prints were not found on the driver's side of the car or anywhere in the car. How do you know?
Backside evidence,
Testified to, Your Honor, by the officer.
not the J.D.'s prints, nobody testified to that.
I'm gonna let him make his argument, you'll have the opportunity to rebut.
The second question that we have, and probably the more important question is, how did the state establish beyond a reasonable doubt that Jay Lee was not alive when Timothy Herrington left for Walmart and returned? Timothy Herrington got back to his apartment at what time? 7:02, something like that. He left Walmart, 7:09. He left Walmart at 6:49. Why would he need the boxcar? He's headed, why would he need the garbage can? Didn't have the boxcar, box truck that was at the links. He drove back. There's no evidence whatsoever that Jay Lee was not alive at that time. Think about why that's important, folks. It's because they haven't proven anything in the apartment to fire, hair, DNA, saliva, anything like that. If he was not alive in that apartment, he got back to Walmart. Now, think about this prospect. We talked about possibilities because the state laid out possibilities. Let's assume, given the state the benefit of all their evidence, that when he left Walmart, Jay was alive. Let's assume he left Walmart and Jay was alive. Let's assume that Jay was still in this apartment. Because if you look at the ping information that we had to introduce into evidence, not the state, we had to introduce into evidence the ping locations 7:15.
You have 4 minutes.
Thank you. 7:15 on. These are the ping 7:21. These are ping locations that basically tracks the area to Molly Bar Trails from Mr. Herrington's apartment. How can they establish Jay Lee wasn't in that car? How can they establish that he was not alive at Timothy Herrington's apartment during that time? Now, Mr. Herrington, possibly, we're talking about possibilities here. If you believe that Mr. Herrington found his way to Grenada, if you believe the theory that they got that he found his way to Grenada with a body, if you believe that, if you find that, how can they state or prove that when Mr. Herrington went to Walmart, Mr. Lee wasn't still in the apartment alive? I'm asking them. Tell you that. found Jay Lee. Look at the lock, resonant lock door. When the door's open, the door's closed, and that again, look at it. You cannot eliminate the possibility. Jay Lee was alive, he left to go to Walmart. He came back, he wasn't. That's a possibility. They've got to eliminate all the possibilities. Not us. They do. They have to eliminate the possibility that Jay Lee got in his car with Timothy Lee. They got to eliminate the possibility that didn't occur. They can't do that. Timothy Herrington, we're not ever denying the fact that he was running away from the car. We never made that a point of contention. They made it a point of contention. Okay, photographic evidence that both of those men were not in that car at that time. It's a possibility. I'm not saying we have to prove that. I'm saying that's a possibility. Ladies and gentlemen, you've got to look at the burden of proof in this case. The burden of proof is beyond a reasonable doubt on all four of them.
Your time's up, Mr. Owen. Wind it up. Your time's up.
You got to look at four options. The only option that's possible in this case, if you take the state's case, everything they have most favorable to them. Most favorable to them is manslaughter. That's the best option for them, ladies and gentlemen. The most reasonable verdict, and the one that's supported by the lack of evidence, is not guilty. Thank you.
We got about another 20 minutes. Y'all good? Y'all gonna need any time to set up, or y'all good to go? All right. Anyone wishing to leave now, you can. We're gonna have about 20 minutes of testimony once we get started. All aboard that comes aboard. All right, y'all can go ahead and close those doors now. Show the jury in. Are you ready? You ready?
Yes,
All
sir.
right. Yeah, you got 20 minutes. All right, looks like everybody's back, and you may begin your final close.
Ladies and gentlemen of the jury, I have a short time to talk to you, so I'm going to jump right into some of the points the opposing counsel brought up. He just came up here and attempted to mislead you. I'll start with the lock audit before we get back into the actual timeline of events, because the timeline matters. So, let's look at that lock audit. It's in evidence, you'll be able to take that. Opposing counsel showed you just the times of 7:34 a.m. But what he doesn't talk about is all the other times, or that this says Stephen Union on it. You remember, I believe Detective Baker testified that the lock report was not accurate, so it couldn't be used. Well, we know, according to the timeline, which is in evidence, it's in that jump shot, we'll get to watch it. Oh, look, 6:45 a.m., he unlocked the door. He's at Walmart at 6:49. Say he got back at 7:02, he unlocked the door. And then, remember, by 7:34, Mr. Herrington has to be all the way over at Boulevard Trails to run out. And according to his interview, he ran over there at a 4-minute mile. So, why is the next time 7:06? And then the next time the door is unlocked is also 7:06. Ladies and gentlemen, inspect all of this. I'm not going to hide it from you. It's in evidence. Because when you really look closely at everything, because we're not afraid of the data, when you really look closely at everything, Tim Herrington's story doesn't line up. Ladies and gentlemen, he also attempted to mislead you when he talked about inveigle. He kept saying force. He said he was not forced to go over there. You will have these instructions in the back, and the judge read them out to you. What is the definition of inveigle? Ladies and gentlemen, inveigle means to coax. It means to convince. It's going to be this jury instruction which you'll have with you. The court instructs the jury that inveigle means to lure or entice through deceit or insincerity. Inveigling has no component of force, but only coaxing. Now, we heard those text messages, and we'll go through them. But the Instagram, that's where we first find out what happens. Because in the Instagram message, Jay Lee writes, after leaving Tim Herrington's apartment for the first time, at 4:36 a.m., he texts, I just wanted to be able to say I had you BDO. Again, fun to have been the first guy. Experiment over. Now, opposing counsel states that that's not Jay Lee threatening him. It's not our position that Jay Lee was actually threatening him. It's about how Tim Herrington perceived it. As someone who is deeply closeted, who's on the down low, who doesn't want people to know. You heard his family, none of them knew. Tim Herrington wasn't publicly out. Look through his Google search history. You'll see the kind of things he Googles. It's all finance. It's all celebrities or rich celebrities. Things that he's aspirational to be. Until this happens. Then And then he reopens the message. He says, all right, another on your floor, you better clean that up. Back to block. Jay Lee did not re-engage that conversation. The only reason it happened again is because Tim Herrington contacts him over an anonymous account. Now, it's never been the state's position that Tim Herrington created the account just to contact Jay Lee. He has another account. He couldn't contact Jay Lee on the account he was blocked, well, because he was blocked. And we know that Jay Lee didn't know who it was because he says, who the F is this? They want to mislead you. They want you to read things that are not there. Just read the messages. They speak for themselves. We don't have to make anything up. We don't have to pretend or read anything into it. I think who the F is that speaks for itself. And then what happens? What happens right after that? What's the right? Tim Herrington doesn't respond, hey Jay, it's Tim. Since we're in a good place, we're in a good relationship and everything, he tries to call him 3 times on FaceTime. After him. Over and over. You know why? Because he didn't want to put it in writing. That's why he's using an anonymous Snapchat account. And then what happens? After Jay doesn't answer his 3 calls, Jay says, well, actually, I believe that's actually when the 14-second Snapchat call happened. And when you look at our timeline of evidence, you'll see that. That's when the actual Snapchat call took place. That was 14 seconds. That's how Jay knew who it was. So they pick up with their same conversation over again. And Jay Lee says, what did you just delete? You made it like this. And what does Tim say? Come back. He asked him to come back. Now, opposing counsel wants to say that Jay showed up unannounced. And truth be told, we don't know how Jay got to the first encounter, but we do know that Tim didn't mind because look at his interview. They want to skip over what he told the police. After he lied the first time. The second time. In that interview, he says he came over like usual and he gave Tim Herrington oral sex like usual. Watch that interview. You'll have all that. He could have said that he showed up unannounced, I didn't know what was going on. He forced me to do this. No. But he said, like usual. That's what they usually do. So then, the conversation continues. Now, remember, Jay knows who this is. What did you just delete? You made it like this. Come back. Jay Lee doesn't respond within a minute. You coming or not? And what does Jay say? He says no. Opposing counsel wants to frame this as if this is not obvious what's going on. Someone is asking someone to come back who is just in a fight with them. That's very clear. From the Instagram messages where he was blocked. And then as we go on, we find out what the fight is about. And Tim asks, why not? Well, Jay tells him, you wouldn't even eat my ass 1 hour ago after I cleaned and everything. Then you proceed to nut in my mouth. Hopefully you ain't been effing nobody raw. And then ask if I'm going to stop harassing you now and that you want to stop linking. You know how much of an asshole move that is. That's what happens the first time. It's right there. Jay Lee is upset, not just because Tim wouldn't reciprocate, but it's all the other actions. He treated him like crap. They had a sexual encounter. Timothy Herrington was satisfied, and then he said, okay, you need to get out. And now, it seems like you're just trying to lure me over there to beat my ass or something. And why is that important? Because think about the earlier conversation right there in the text messages, where he told him how he was treated. You just treated me like crap. You told me you don't want to see me again. You told me to stop contacting me. Now you're asking me to come back. Why? That's unusual. You're trying to lure me. Of course Sheldon feels like he's trying to lure him over there. He just treated him horribly. Then, Tim says, you tripping. I feel bad because we're cool. So I'm not trying to end it like this. Again, telling him he doesn't want it to be over. He doesn't want to end it like this. There's nothing more to read into that. It's right there. Jay says, how are we cool? You barely want me to text you. Opposing counsel skipped over all these messages when he was going back through because he doesn't want you to see the real conversations. He wants to make it look like Jay Lee was inviting himself over. Jay Lee was pursuing. Jay Lee is asking Tim, how are we cool? You don't like me. You don't want me to text you. You just told me that you want to stop leaking. You just told me to stop harassing you. Now, you're acting all different. That's obvious. Then, Tim says, you're a cool person. They go on to talk about when was the last time that Tim had sex. They had that conversation. And what do we see? Jay says, because he sees Tim trying to invite him over, and he clearly likes Tim. And so he says, okay, I'll come over if when I get there, I'm going to have oral sex. You're going to give me oral sex. And Tim, rather unenthusiastically, I might add, says, okay. So much so that Jay doesn't even know what he's talking about. He says, just okay? And Tim later says, I'll do it. See, that's important because that's the lie and the deceit. Think about Tim's interview, which I want you all to watch. The defense says that we don't know what the thing that's ever been done before is. Tim told us what it was in the interview. Tim says, oral sex. He says, I've never done that before. He says, he invited him over to make it up to him because he's never done that before. That's the thing. And it's very obvious from the interviews, from the text message, and from what Jay even said. Opposing counsel put that 14-second phone call. He wants to put it where he thinks it should go to help his story. But where it actually went was right after Tim called Jay 3 times, he didn't answer, all doubt.
You have
It's
2
about-
minutes.
Thank you. It's about what is reasonable. He asked 2 questions. How do we know Jay Lee was not alive when the car arrived at Molly Bar Trails? We know that because at 7:28, the phone shuts off. And that's right before he gets to Molly Bar Trails. And by shuts off, we don't know if it was broken, we don't know if it was damaged. But we also know that from the testimony of Jose Reyes and Jay Lee's mom, that he never let anyone borrow his car. Jose said he don't let his car let him go get some gas, put gas in. So we know that. We also know that when the car is found, all his things are in it. The things he would need to move on, to live a life. He says, 2, how does the state establish that Jay Lee was not alive in that apartment when Tim returns from Walmart? Tim Herrington says in his interview that Jay Lee left a little bit before him. That Jay Lee left before him. Watch Tim's interview. He says he left, Jay Lee, and then Tim left. And then after that, he says he went to Walmart. We also know from witnesses that said that Jay Lee never had any reason to be at Molly Bar Trails. In fact, he didn't really know anybody over there. They talked about talking to people over at Molly Bar Trails who said that Jay Lee was never over there. And one big point.
That's not
Is
my
that-
ring, to be sure, but I was gonna ring if you didn't. You can wind up real shortly.
I will.
okay?
One big point we know for sure is that how did Tim Herrington get to Molly Bar Trails? When we asked those 2 questions that he asked, Jay Lee was not alive, and Jay Lee never left or was alive when he returned to the apartment. You heard the testimony. There's one way in and one way out of Molly Bar Trails. One way in and one way out. You never see Tim Herrington run in. Not only do you never see Tim Herrington run in, you do see a few cars go in. But if a few cars go in, if Tim Herrington was in one of those cars, why didn't he just tell that to the police when he talked to him? And if that's the case, when he got out of the car to pretend the job, why did he catch a ride immediately after running out of Molly Bar Trails to get into another car to take him home? None of those cars dropped him off. It's not about possibilities. What is reasonable? Sometimes the obvious answer is what it is. Ladies and gentlemen, July 8th has always been a special day for the Lee family. Stephanie Lee's birthday, and she testified that every year her son, Jay, calls to sing her a happy birthday. She's never going to hear that again. She's never going to call again.
Just wind
But
it up.
today is Tim Herrington. Tim Herrington's day. It's time for him to be held accountable for what he's done. So when you go back there, look over all the evidence. Take your time. Dive into the data and find the only verdict that justice demands. That's guilty.
All right. Ladies and gentlemen, jury,